Before we start the program, I would like to share some housekeeping information. First, this is not a CLE accredited program. Second, you may submit questions at any time during the program using the Q&A function at the bottom of the screen. Finally, this program is being recorded. Welcome to Review of the Supreme Court's Term Criminal Cases, sponsored by the ABA Criminal Justice Section. And now we will hear from Professor Rory Little. Rory?
Great. Hi, Patrice. Thank you very much. That's Patrice Payne, who is a staff lawyer with the Criminal Justice Section of the ABA. I want to welcome everybody. I'm going to be reading a little bit, so I may not be looking right at my camera. I'm happy to see close to 100 participants joining this program. It is put on by the Criminal Justice Section of the ABA. The mission of the Criminal Justice Section is to provide a gathering place for lawyers who practice or work in all aspects of the criminal justice system, whether this be as a judge, a defender, a prosecutor, policy experts, law enforcement folks, and very importantly for today, law students. So today, because we're remote, it's wonderful that students are able to join us. Normally we're in a physical location somewhere and students can't get in. So welcome to those of you who are currently law students. We will be discussing, of course, all of the criminal law docket of this term, but we have certain cases that we picked out for more detailed discussion. And before we dive in, I want to say thank you to Patrice Payne and Carol Rose of the Criminal Justice Section for their assistance with this panel. Carol has been with this program for, I think, over 20 years. So she's done a great job for us. Here's how it's going to work. I'm going to introduce our panelists one by one. I'm going to give you a brief overview of the term. There will then be presentations from each panelist with some dialogue between us. And then at least 15 minutes at the end for questions and answers. So you can type questions and answers into the Q&A field, and I'll try to monitor that. I may ask questions during the program, but certainly at the end we'll reserve some time. We're not able to activate your audio if you're participating under this hosted system, which means I can't let you speak it out loud. I'll have to just read whatever's typed, and that's too bad because I miss the interchange between the meeting participants at this meeting. So let me introduce our panelists. Let me just say, let's see if I can make this move. There we go. This is Judge Pearson and some information about her, but let me just say more generally what's really great about doing this on Zoom, while I miss the in-person contact, is it opens up the nation in terms of who could be on this panel. So we have people from all over the country on this panel, and we're very lucky to get people that I'm about to tell you about. Their credentials and their accomplishments far exceed what I'm about to say about them, and you can probably find them all on the web. If you look, you can find our email addresses on the web too. Judge Pearson, I think probably a phone number rather than an email address. And I am going to, once in a while, after I finish these introductions, turn off my screen so that we are just talking with you in the dialogue that I think is nice to have on this program. So, the Honorable Benita Y. Pearson is a U.S. District Judge for the Northern District of Ohio. She's based in Youngstown, where she's been sitting as a district judge since her confirmation, which is now almost a decade ago. Before that, Judge Pearson served as a U.S. magistrate judge in the same district. As you can see from the screen, she's been a federal prosecutor as well as an attorney in private practice. And this is true of all of the panelists today. So you law students, I'm making a pitch here for clerking for a judge if you can find one. Judge Pearson began her career as a law clerk to a federal judge, just like the other panelists. Okay. Judge, not yet. Professor Daniel Harawa, probably mispronouncing, I'm sorry, Harawa, it teaches law at Washington University in St. Louis, the School of Law there, and he is also the director of their appellate clinic. And I'm happy to say he's also part of the Criminal Justice Section serving on the amicus committee. He has also worked in private practice. This is another unifying theme for you law students, and has served as a public defender and a federal judge law clerk, and most recently, counsel to the NAACP Legal Defense and Education Fund, where I still think he serves as advisory counsel. And we're very fortunate to have Daniel with us today. I will now move to Carla Laroche. Professor Laroche teaches law at Florida State University College of the Law, which is in Tallahassee. She also directs their clinic in gender and family justice. And just like the other panelists, Professor Laroche has worked in private practice and also has served as an attorney in the public interest. And she too is active in the criminal justice section as the co-chair of our Women in Criminal Justice Task Force. She also began her career clerking for a federal judge. I'm not going to say anything more about me other than I'm very happy to be doing this panel again. Nobody remembers when I started, but it might have been a long time ago. I will be sending you a booklet of summaries. This will be a 40 to 50 page booklet summarizing the entire term with a lot of information in it. You'll get that after this panel instead of during the panel. And we have your email addresses by your registration. The last thing I want to say, though, is for you law students and others watching, the criminal justice section would be thrilled to have you join our little band of disruptors, you might call us. And any of us on the panel could give you more information. You could certainly email Daniel and Carla or me after the panel ends. You can find our email addresses on the web, and we can tell you more about how you join. I think we can probably get a free membership for the first year. I say that without having any full authority. And there are lots of different roles and committees that you could serve in. So I urge you to consider it. The criminal justice section does a lot of good in terms of pushing policies, both legislatively and judicially and within bar associations. Okay, before I turn the podium over, the virtual podium over to Judge Pearson, I'm going to give you a brief overview of the term, and I've switched the slide now. I assume it's true, of course, we've all suffered from the hardships of this unexpected disruption caused by the COVID-19 pandemic this year, starting in March in sort of a formal way with lockdowns, but beginning even earlier with many people being ill and not knowing that we were in a pandemic. The court and the justices were no exception to the disruption. So as you probably know, 2 months of oral arguments were canceled. That has not happened since the Civil War. They canceled 1 month of oral argument in 1918 during the Spanish flu pandemic, but not 2. And then after they figured out that this was not going to end soon, they scheduled arguments for May in 10 cases. They selected 8 very important cases and 2 cases they didn't think were so important, but they used them as their first 2 cases to see how the technology would work. And they did remote oral arguments by phone, which is the first time that's ever happened. They're still not using video, but the arguments by phone actually went better than anybody had expected. And in some sense, the court has been forced into the 21st century a little bit by doing this. Whether they will continue phone arguments and whether they will continue to live stream their arguments remains to be seen. But they did live stream the audio this year. And that meant you could listen live as they asked their questions and as people answered. They had the same problems on Zoom that we all have by not, forgetting to mute or forgetting to unmute. Occasionally cut off, Justice Alito at one point was cut off a couple times, had to come back on. And you can now listen to all the oral arguments in the Supreme Court, not just the live streamed ones this year, at a website which is on the Supreme Court's own official website, supremecourt.gov. Because of the cancellation of arguments, 12 cases were kicked over to next term and will be argued in October. So this was a historically small number of cases, only 61 merits cases and only 53 signed opinions. And as I'm sure Judge Pearson could tell you, if you only have 53 cases a year, you're doing pretty well as a judge. And if you divide that by 9, I sometimes say is the easiest job in the world. They've only got 7 or 8 cases apiece. Of their 61 cases, 27, and I put a question mark because it depends how you count, where criminal law are related. And we're going to go over a bunch of those now, but not all of them. Are there any patterns? I've listed some on the slide here. I think what's very interesting is that Justices Kavanaugh and Gorsuch continue to diverge. They do not always vote in lockstep. They disagree somewhat, not frequently, but it's not infrequent that they disagree. And at the same time, both of them, having been appointed by President Trump, voted against the administration position or the president's personal position in the presidential subpoena cases, and we'll talk about those in a minute. Justice Kagan continues to be a powerful writer and force on the court. She's a strategic long view player, and occasionally, this is my theory, she votes with people that you wouldn't expect her to vote with. Part of it was that she was the Solicitor General, so she has worked as a government lawyer. But part of it, I think, is she joins when she can join something in hopes of developing some friendship and getting some joins back in the long run. Justice Sotomayor is undoubtedly the most often pro-defense member of the court. She writes really, I think, outstanding, powerful dissents in certain cases, and often calls attention to aspects of the case that the majority has sort of elided. At the same time, Justices Alito and Thomas are almost always pro-prosecution. They seem to vote together more frequently than, say, Justices Kavanaugh and Gorsuch. And then, you know, Justice Gorsuch has turned out to be a bit of a maverick, voting. I say he's a Western maverick because he voted in favor of the Native Americans in a case called McGirt versus Oklahoma, which many people attribute to him having lived in the West most of his life. And then maybe the biggest picture, and the last thing I'll say, is that Chief Justice Roberts firmly became the Chief Justice. He's been the Chief Justice now for almost 15 years. But boy, this term, he really solidified his position. Whether you like him or you don't, his position, his ability to be in the majority and move a majority of the court in towards certain directions seems to be very firmly established this year. There's a recent series by Joan Biskupic on CNN's website with some inside stories about the term if you're interested. Okay, with that little brief introduction, here's a picture of the court today. Please notice that I say it's not an official portrait. I had a student put headphones on all the justices. We don't actually know how they did it at home. They all stayed home. They didn't come into chambers, although my understanding is Chief Justice Roberts is coming into chambers occasionally to run the administrative side of the court. And so we don't know whether they were wearing their robes or not, but headphones seem pretty clear that they were somewhat low tech in their tech abilities, just like me. All right. Here's the cases we're going to discuss today. I don't expect you to read this whole slide. I just want to point out a couple things. First, everything is fair game for your questions if you want to ask about cases we don't discuss. The presenters have chosen, in some sense, their favorites to talk about, which means, you know, they're not necessarily the biggest cases of the term, but they are the biggest decisions that these presenters chose. I think you'll find them all interesting. You put your questions in the Q&A field. I'll try to save at least 15 minutes for questions at the end, and I may ask some questions as we go. You'll see that there's roughly 3 to 4 cases per participant. The colors here don't mean anything. I just put them in for a little variety. And with that, I am going to, I think, stop sharing my screen and let's see what's next. Yeah. And turn it over to Judge Pearson. All I have to do is find my cursor, which, oh boy.
I can even start while you're doing that. I think there's at least a small image of me there, isn't there, Professor?
Yeah, why don't you go ahead? And
all right, well, you search for the cursor, and thank you for the kind introduction. It's a pleasure to have the opportunity to work with you and my co-panelists, and also those of you who have the time or have taken the time to be with us today. And as Professor Little said, we're not going to go into depth about all cases, but we do hope to talk to you about some that we've found particularly interesting, and hoping you will as well, and maybe you'll also have some questions for us. I'm pleased to start us off by talking about a couple of cases that are similar in several ways, and they both involved sitting president of the United States having been subpoenaed, well, having had subpoenas for information from the president. Now, let me tell you what I mean by that. These subpoenas were issued to third parties, not directly to Mr. Trump, but they were for information about him and others. You're going to hear that these subpoenas were of two different types. One was a group of congressional subpoenas. 3 different committees sought information from a third party, from third parties. Another was a criminal subpoena. Cyrus Vance, New York County District Attorney, sought criminal subpoenas, again, for information about the president, but not from the president. So in 2 separate cases, Trump versus Vance and Trump versus Mazars, the Supreme Court was put to work. And I agree with you, Professor Little. Those are important cases, but if I only had 8 or 9 cases a year, I think I'd see this job in a whole different light. But back to the point. In 7-2 decisions in each case, Justice Roberts wrote for the majority and ultimately held that neither Article 2 nor the Supremacy Clause provided absolute immunity to the president for having subpoenaed information sought from him. Also, there was a decision specifically laid out in Vance, but also echoed in Mazars, is that there's no heightened standard. So if you listen to the oral argument, and I know several of us on the panel like to do that sort of thing, and maybe some of you do too, you would have heard Justice Ginsburg ask the question using the common law maxim that the public has a right to every man's evidence. And then she concluded the question by asking, isn't the president one of every man? And ultimately, Justice Roberts, along with the majority he wrote for, the only dissenters were Justices Alito and Thomas, said, yes, he is. He's not absolutely immune from criminal subpoena, nor congressional, but he does have a right to protect himself in the way that anyone else would if such information were sought. So for instance, the legal or constitutional protections that you'd be able to bring when faced with a subpoena, such as the subpoenas overbroad, the subpoenas issued in bad faith, the subpoenas timing is problematic, or rather, as President of the United States, that there is an attempt just by the issuance of the subpoenas to influence his ability to lead or his official duties, to somehow impede an official constitutional action. It's important to recognize when you study these cases that in both, the subpoenaed information regards the president and others, but none regard the office of the president. The information sought is for actions before Mr. Trump became president. So without doing any more than I believe he was required to do, I really applaud the way Justice Roberts wrote the subpoena. And I think if you read it, in addition to listening to the oral argument, there's some parts of it that you'll find great interest in. I know I did. One of my probably most admirable affections for Justice Roberts, if I can say that about the Chief Justice of the United States, is the respect he gives to the court, especially the trial courts. We're the workhorses, and he recognizes that. He's done as much in one of his end of the year addresses. And he does that in the conclusion of the Vance decision. He reminds us that in this decision, the Supreme Court is reaffirming that the president is neither absolutely immune from state criminal subpoenas seeking private papers, nor entitled to a heightened standard And then he says this about district courts and appellate courts, but I took it personally. So I think he's mostly talking about the trial court judges. He said, the guard furnished to this high officer lies where it always has in the conduct of the court, applying established legal and constitutional principles to individual subpoenas in a manner that preserves both the independence of the executive and the integrity of the criminal justice system. In using that logic, Justice Roberts, or the majority, found the president is not absolutely immune. Article 2 nor the Supremacy Clause categorically protects him, but he did say, look, there might be some protections. Because the arguments made on behalf of the information sought from the president was at such a high level that the majority could not find that the subpoenas were not to be processed as they normally would, there was a remand. So now the guard, trial court judges like myself will have the opportunity to decide what questions there are, what protections might be legally and reasonably sought. And in Mazars, the case with the congressional subpoenas, Justice Roberts suggested some inquiries. He suggested that some of those inquiries are necessary because there is a clear implication of the separation of state powers when Congress subpoenas records from the president, even though not during his active office. And some of those factors are whether the asserted legislative purpose requires involving the president or his papers, or can the information be sought elsewhere? Whether the subpoena is broader than reasonably necessary. Whether Congress has offered to establish that the subpoena advances a valid legislative purpose, and what burdens a subpoena imposes. So that carve out, I think, was correctly and necessarily made in the Mazars decision because there is an implication of the separation of powers. Now, I'm trying to watch my time, but I want to just tell you that in recognizing that the president is not absolutely immune from subpoenas, it isn't as if Justice Roberts or the majority had to create new law, but rather they went back 200 years and relied on what was already established to reach this ruling. Now, keeping that in mind, the other case in which I had a keen interest in, I know some of the panelists also do, so there'll be more discussion, is Ramos versus Louisiana. And in this case, not a subpoena case, but this is a case regarding Mr. Ramos, who was convicted of a crime in the state of Louisiana after a jury trial. The jury trial reached a verdict by a vote of 10-2. So it wasn't a unanimous verdict. And as a result of being convicted by 10-2, Mr. Ramos is serving a life sentence without the possibility of parole. So the question became, was that a constitutional sentence? A constitutional trial right? It's long thought to be a unanimous jury verdict. And interestingly, at one point, the state of Louisiana did require unanimous verdicts, but it changed in 1898 to require only a 10-person majority to convict in a serious matter, such as a criminal case, non-misdemeanor type case. Changed back in 2018. Well, in the Ramos case, an interesting case, the majority had no problem finding, although it took some machinations, but no problem ultimately finding that the Sixth Amendment guarantees a unanimous jury verdict. Where the difficulty came from Justice Thomas's perspective, for instance, is how the Sixth Amendment makes that requirement on state courts. As I think some of you may be familiar with when you know Justice Thomas's jurisprudence, he prefers that we use the Privileges and Immunities Clause instead of the Due Process Clause of the Sixth Amendment to require states to do certain things. And in this case, it's to find unanimously a guilty verdict. Well, he was no different in this case, but he was steadfast that state courts as well as federal courts must have unanimous verdicts when a serious penalty is imposed, such as Mr. Ramos suffered. What really gained more attention than you might expect from a case like this is how the court reached its decision to basically find that Louisiana's law was unconstitutional at the time Mr. Ramos was convicted. And it had to overrule a longstanding decision. In 1972, the Supreme Court ruled in Apodaca. And that odd 4-1-4 decision was a sticking point. But interestingly, and I appreciated it, Professor Little, when you said in the introduction that Justice Sotomayor writes with a force unequaled by any justice on the court, is my opinion. She said right out in her concurring opinion, Apodaca was on shaky ground from the start. And I think that's best exemplified by it being circumvented, by the court working around it and reaching decisions wherein it had to decide whether or not stare decisis would be observed. And I think we can all agree stare decisis, the doctrine that usually lends itself to keeping in place a prior decision, sometimes doesn't carry the day. And Justice Sotomayor had no problem finding, and I was very pleased that Justice Kavanaugh was able to speak forcefully on this too, that racial motivation was part of the reason that Louisiana had the 10-2 majority, allowing that to be enough to impose a serious sentence such as life without parole, or that which is akin or the result of many criminal cases. And I think what Justice Sotomayor meant to convey, certainly one of the things you can reasonably take from her decision, is that there are many things we must consider when you look at a case and decide whether or not it deserves stare decisis or precedential respect. And in this case, I don't think she believes Apodaca even deserves that. But she and others also wrote, and as you'll see, there's plenty of concurring opinions as well as a dissent. How wrong is the decision? In this case, because the decision results in an uprooting of criminal procedure, Justice Sotomayor had absolutely no problem in finding that it should not only be considered precedential, but not followed going forward. And certainly others agree with that. Now, one of the points that was made and not resolved in this case that set up a case for next term is, well, is Ramos retroactive? Mr. Ramos wasn't the only person who had a 10-2 verdict or something less than unanimous verdict, or may even have been encouraged to plead guilty because he worried whether or not he'd get a 10-2 verdict. So as a result, the question of retroactivity has been teed up for next term. And I think the Edwards v. Vanny case is where we're going to hear the justices speak about that. And I know we'll all listen with interest. There was a lot of discussion in many of, and certainly in Justice Gorsuch's writing for the majority, as well as the concurrences, about where do we draw lines? How do we uproot real world decisions? What reliance interests and what costs of uprooting those reliance interests must be paid. So we'll have to stay tuned. I hope within my time, if I'm a bit over, my apologies. I know we all have something to say, and I'll chime in again when I can, Professor Little.
You did a great job, Judge. Let me ask you a question that's come up in a Q&A. Just, I didn't prepare you for this, so we'll see. Can you, I assume, Vance, the Trump versus Vance case is a state grand jury subpoena, but I assume as a federal judge, you sometimes are asked to enforce subpoenas.
Absolutely.
Yeah, so how does that happen? What's your experience in the area of enforcement of subpoenas? What do people have to do to get them enforced?
Well, sometimes you just serve them. And I think, again, listening to the oral arguments, it was made clear that the target, the third party, was prepared to reluctantly perhaps, but to respond to the subpoena. So sometimes sometimes there's just a response, but there could be an objection. The objection may be in the form of a motion to quash or a motion to modify. Maybe it's quash is look, no way, no how, which is what I think President Trump's counsel and the United States attorney arguing on behalf of the president wanted. But sometimes there's just a request to modify the subpoena, narrow its scope, make sure that the timing, either in terms of production or how far back the information sought is reasonable and responsive to the needs. There can be other remedies as well. In one situation, I think a question reasonably to be discussed regarding especially the New York County subpoena is, can this wait until Mr. Trump is out of office? So that's another discussion that might come up. But as Justice Roberts wrote, the guard is ready. No trial court is unfamiliar with these kinds of questions, these kinds of issues that will urge protections. And similarly, regarding the implication of separation of powers, there'll be a robust discussion there. Is that helpful?
Yeah, great. And I would only add, and you may have already said this, on the Vance and the Mazars case, what's remarkable really is that the court was unanimous on the no absolute immunity for the president. I think that we have to all believe that the identity of the current president was in people's minds, but Justice Alito at one point said, well, this will apply to all presidents. And yet they really were unanimous, no immunity completely, either from congressional or state grand jury, and that it is up to a case-by-case thing. And even in the Mazars case, Justice Thomas seemed to say that Congress can't subpoena things at all. So maybe that was 8-1, but then he said you could subpoena them if you did an impeachment investigation. So the rejection of absolute immunity is consistent with U.S. versus Nixon, for example, in 1974, which is, it's nice to see the court as an institution. Do Carla or Daniel, anything you want to add on the Vance or the Mazars Trump case, or Ramos for that matter?
Sure. So just about Ramos quickly, I think what's really interesting is the history, as the judge alluded to, of Louisiana's non-unanimous jury provision. And so in the 1898 Constitutional Convention, the design or the purpose of the convention was to establish the supremacy of the white race. And one way Louisiana tried to do that was to return Black people, in their words, to as close of a status as slaves as possible. And so the non-unanimous jury provision really was designed to allow white people to more easily convict Black defendants, but also to nullify Black jurors' voices as Black people gained the right to serve on juries. And it worked just as intended. So even today, there's a marked disparity between Black defendants versus white defendants in terms of who is convicted by non-unanimous juries. And the jurors who are most often in dissent happen to be Black jurors. And so I wrote an amicus brief when I was at LDF, and I spoke with Black people who were jurors who were overruled in essence. And they really spoke to how they felt like their voices didn't matter. They didn't feel like full citizens. They felt like it stripped them of some of their power in a democratic society. So the racial dynamics that underlie Ramos, and that will kind of feature again, I hope, in Edwards, when the court decides whether it's retroactive, will really be interesting to see what the court does with that.
Yeah, I was. Thank you, Daniel. That history is so powerful, and I think so damning. The idea that Justice Alito could say race is really, that racial history is irrelevant to this question is sort of astounding to me. And I was pleased, Judge Pearson, you mentioned this. Judge Kavanaugh wrote separately to write at a length that he doesn't have to write. I mean, he doesn't have to write anything about the racial history. And this is reminiscent of Justice Kavanaugh a year ago in the Mississippi versus Flowers case, where he also wrote about the racial bias, discrimination, bigotry in jury dynamics and criminal justice dynamics in general. And I'm convinced, and I know Justice Kavanaugh did not take the bench as the most popular justice in history, that that this is something he actually believes. And so I'm looking forward to seeing how this works out going forward. The other thing I wanted to mention on Ramos, and Carla, I have, if you want to say something, maybe I should go first. I have one more thing about Ramos, but did you have something you wanted to talk about?
No, I appreciated Daniel's discussion of history of peace.
Yeah, great. Well, the only other thing about Ramos is it became a stalking horse for the justices on the issue of stare decisis, right? Should this Apodaca case be given precedental force? If so, should it be overruled? And the majority says, first, we're not sure it's really a good precedent, but second, even if it is, we should overrule it. And then justices wrote separately at great length about their theory of stare decisis. Justice Kavanaugh, in particular, took this opportunity to write a whole concurring opinion about a theory of stare decisis with different factors than the court has said in the past, or at least differently divided. And I think they are all very aware that Roe versus Wade is coming to the court soon, next term, maybe certainly by a term or two, and that this issue of what is the force of stare decisis is going to be a big issue for the court. So in some sense, there's stuff going on in Ramos that had nothing to do even with the question. They just wanted to get their theories on. Chief Justice Roberts said some things about stare decisis. I think he was trying to answer Justice Kavanaugh. So Justice Thomas, of course, has a whole different theory. So that was a stalking horse.
Professor, I'll only add, while I agree the 18 pages from Justice Kavanaugh, I think you're right, portends what's to come, but it's sort of a weak plank on which to place all this stare decisis dependence, right? Because Apodaca was an unusual case. And I think Justice Sotomayor was correct, on shaky ground from the day it was issued. But nonetheless, you're right, it was a motivation for a lot of expounding on stare decisis.
Well, I think you're right. That's, in a sense, that's what's so amazing that Kavanaugh decided to write all about stare decisis in a case where the truth is the precedent was not even really a precedent. You know, it's a 4-to-1. Anyway, you're absolutely right.
By you than me.
Judge, did you want to talk about Lomax, or did you want to kick it over to Professor Harawa?
I'll kick it over. You know, dismissals are dismissals is pretty much what Lomax stands for. Maybe in questions or towards the end, but we've all worked hard to prepare, so I'll kick it over to Professor Harawa, and if there's more time, we can come back to it.
Great. Good. Daniel.
Awesome. Well, thank you. So just one more word quickly about Ramos, which I think is interesting, is Justice Alito's concurrence, where he says really talking about racism is uncivil. And he's joined by the Chief Justice, which isn't surprising, I guess, given his statements in Parents Involved in Shelby County. But the fact that Justice Kagan joined that part of his dissent, I think, was a little shocking to some people, because the idea that we can't talk openly about race and racism, or that it's somehow uncivil to bring up the racist history and the blatantly racist history of Louisiana's law is, I think, was a little surprising to see Justice Kagan join that part of the opinion. But moving on, so the case I'd first like to discuss is a case that also has a clear racial and immigration implications and involves tragic facts, as the Supreme Court said. And that case is Hernandez v. Mesa. And the facts are important to kind of spell out. So Sergio Hernandez was a 15-year-old Mexican national who was playing in a culvert on the US-Mexico border in El Paso. And so the game was Sergio and his friend would run and touch the fence on the US side of the border and then run back to the Mexican side. Border Patrol agent Jesus Mesa detained one of the kids who was playing the game. And then as Sergio was running back to the Mexican side of the border, Agent Mesa shot Sergio in the face, killing him. So the federal government cleared Agent Mesa of any wrongdoing, so he didn't face any criminal liability in the US. Mexico requested to have the agent extradited to face trial in Mexico, but the federal government refused to comply. So without any avenue for criminal liability, Sergio's parents sought to at least hold Agent Mesa civilly liable and sued him in federal court alleging that he violated Sergio's Fourth and Fifth Amendment rights to be free from excessive force. And so while there's a statute that allows you to sue state actors for violating your constitutional rights, Section 1983, so if Agent Mesa was a Texas sheriff, there's a clear statute that would have allowed Sergio's family to sue him. There is no comparable statute for federal agents. And so the only way we're able to sue federal agents for violating constitutional rights is through a 1971 case called Bivens, where there the court held that the Constitution includes an implied cause of action under the common sense reasoning that if there's no remedy to a violation, then the right becomes a lot less potent, if not meaningless altogether. And during that period in the court, it was willing to read causes of action or implied causes of action or remedial provisions into statutes in the Constitution. But since 1971, obviously the makeup of the court has changed dramatically. And they've retreated from this position where they now are of the mind, the court's now of the mind that it's improper to read kind of remedial provisions into law because that arrogates lawmaking power essentially onto the court. And that there could be a host of reasons why lawmakers wouldn't want to include remedial provisions or damages provisions in a law, and that it's not for the court to supplant or supplement the law in that way. So although the court has not overruled Bivens, although Justice Thomas and Justice Gorsuch believes this decision should be overruled, the court has made clear that it's reluctant to extend the case to new contexts, especially when there are what the court calls special factors counseling hesitation. And so here, the court had to decide whether Bivens would extend to Sergio's case and whether Sergio's family could sue Agent Mesa in federal court under Bivens. And the court said no. Justice Alito, writing for a 5-justice majority, held that the cross-border shooting was a new circumstance because of the foreign policy and national security implications that's involved in a cross-border shooting. The court said it should be really hesitant to extend Bivens to this circumstance, and thus essentially says there is no avenue for relief for Sergio's parents. So not only will there be no criminal liability, there is also no civil relief for Sergio's parents for the killing of their son. Justice Ginsburg, joined by Justices Breyer, Sotomayor, and Kagan, dissented. She argued that this wasn't a new circumstance. So Bivens itself involved what Justice Ginsburg called a rogue federal law enforcement officer violating Fourth Amendment rights. And it was essentially the same fact pattern here. And she said the majority overblows the national security or foreign policy concerns because this is just a lawsuit against a single agent for what Sergio's parents claim was an unconstitutional act. And there really aren't these broad national security foreign policy concerns as the majority suggests. What I think is most interesting about this case is how that fits into the moment. So we're focused as a country on police accountability and what it looks like to hold police officers accountable. And I think Hernandez really exposes a weak spot in our legal structure in that there is no actual statute that allows us to sue federal agents for violating our constitutional rights. And now, given that the court is clearly cabining Bivens, if it doesn't outright overrule the decision at some point down the line, it's clear that there is a need for a federal analog to Section 1983 for when it's federal agents who are doing the constitutional violating the Constitution. And it really struck me as we see federal agents being deployed to cities across the country in response to Black Lives Matter protests, and when we see some of the tactics that these federal agents are using, that if there is not some kind of federal statute passed, there really could be no recourse for the violating of constitutional rights. So what I'd be interested to see is if there's going to be some kind of legislative push in light of kind of modern events or current day and Hernandez, and kind of how it's important that when we think about rethink qualified immunity, that this is something that may not be as interesting to think about, but it really is an area where we need to be focused on, because I think, as everybody agreed, as all 9 justices agreed, the facts of this case are tragic, and the idea that there's no recourse at all anywhere for what happened here really shows a weak point in our legal structure. And so with that, I will pass it over to Carla, because I know she's going to discuss a Fourth Amendment case too, unless any of my panelists have any thoughts on Hernandez.
I had a question.
Yeah, go ahead, Carla, because I want to talk about Hernandez a little more too. Go ahead, Carla.
Professor, I'm just wondering if you can extend your last point a little further in why people are not focused on this issue. Because of where we are right now, qualified immunity has gotten a lot of the discussion, but not this civil remedy that doesn't exist. And so would it make more sense to put them together, and why hasn't that been done? If you can just explain that piece in your thoughts.
I mean, it's a great question. I mean, so I think one of the reasons why, we interact, or Black and brown people interact more frequently with state police officers than federal police officers. So it seems, and so qualified immunity shields, it's often a shield for state police officer accountability. And I don't think we see the fact patterns, at least not in the news as much. It's just not in our public conscience as much as the idea that there are also federal agents who police people every day, and that there needs to be a way to hold them liable. So hopefully this case kind of spotlights that issue, but I do think the conversation may change a little bit given what's happening in Portland and Chicago. I think we now know that there are examples of federal agents and police officers going to streets, and it's not just cross-border situations, it's coming to our neighborhoods and policing protests. And so I think when we see more of that happening, I hope this is part of the conversation, it becomes part of the conversation. Not just for situations like Sergio, which is tragic and unfortunate, but as we see a federal government that seems to have a very muscular view of its power to police us, I would hope that codifying Bivens is part of the conversation at some point.
It's another sign that the election that's coming up in November means something. I just wanted to, what you said was wonderful about Hernandez. I just want to expand even more. Some people probably say, well, why isn't there some other remedy? And the truth is the Hernandez parents were cut off sort of at every point. The Mexican authorities sought extradition of the agent for criminal prosecution, and the United States denied that. There was a disciplinary investigation within the Department of Justice of this agent. The Justice Department decided there was no disciplinary violation. The state authorities, maybe not surprisingly, refused to prosecute. And there's no state civil suit because of an absolute immunity, really, for federal agents. And then we get into this whole debate, which is also happening right now, about qualified immunity of agents. And many people think that doctrine has been distorted. Bivens is based on a very old statement by the Chief Justice John Marshall, who said every right should have a remedy. And he was just repeating common law. Every right should have a remedy. And the idea that there are rights in the Bill of Rights that have no remedy because Congress won't pass whatever it needs to pass and the Constitution itself doesn't support a lawsuit, I think runs counter to much of that common law history going back 200 or 300 years. And so the current court's view, we should overrule Bivens or we should cut back and never extend it, is not necessarily going to be the view of a majority of the court in the future. This is 5-4. And again, I think no matter who wins the election, there are going to be vacancies on the Supreme Court, and it matters who's appointing. Anyway, Carla, you're welcome to take over on your next case, unless the judge has something she wants to say. No.
Not yet. Thank you.
Okay.
So I will be talking about Glover, another Fourth Amendment case, but in this instance, reasonable suspicion. To start off, I will present 3 questions as the audience. Is it reasonable for you to assume that someone with a revoked driver's license might be driving the car that they own? What information are you basing your answer on? And do certain groups of people get the benefit of the doubt when you're answering those 2 questions? So the facts of the Glover case were stipulated at trial. There were no witnesses. A police officer ran a truck's license plate. The owner of the vehicle had a revoked license plate after the officer ran the license plate. Without any additional information and without observing any traffic violations, the officer stopped the truck. Turned out that the driver, Glover, was in fact the owner with the revoked license. As a result, he was convicted of being a habitual violator under Kansas's laws. In the decision which Justice Thomas wrote, he reversed the Supreme Court holding that the officer's actions were reasonable. He did have reasonable suspicion to stop the truck. The Kansas Supreme Court had actually supported the motion to suppress the conviction as a result of not having reasonable suspicion. But here was Thomas writing for the majority saying there was reasonable suspicion. Justice Thomas based his information or his opinion on the totality of the circumstances and the fact that there were no negating facts to his assumptions, the officer's assumptions. Also, common sense judgment and inferences are allowed under the Fourth Amendment about human behavior. And so therefore, stopping someone based off of running their truck license plate is enough reasonable suspicion to then stop them. Sorry, I'll do that backwards. It is reasonable to stop someone once it's indicated that from their license plate that they have a revoked license, even if they might not be the driver. So that first question of, isn't it reasonable to assume someone with a driver's license might be driving the car that they own? How are you basing that off of is the second question. Some might think that if a license is revoked, they will not be driving their own truck. Others might say, oh no, I've had cousins, I've had brothers who, even when they have a revoked license, they will still drive because they need to get to work. They need to pick up their kids and there's no one else available. The focus on Justice Thomas's opinion was on empirical studies that indicated that people still drive even if their licenses are revoked, and on the fact that someone who owns a truck or owns a car might be driving even if their license is revoked. Justice Kagan, in a concurrence that Justice Ginsburg joined, stressed that this decision was limited to the facts and to the law in Kansas, which looked at the revocation statute and said that there's already an indication that, or one of the indications of reasons why a license will be revoked is because of a disregard to human life. And so they tried to narrow the opinion by saying, only these facts, only this state law. The other question of information based on what? Is it based off of your experience as a law enforcement officer or as an ordinary person? Justice Thomas said it is based off of human behavior, your knowledge as an ordinary person, and yet Justice Sotomayor, who was the sole dissenter, stressed really the other piece. This should have been based off of a law enforcement's experience, law enforcement officer's experience. Should a law enforcement officer stop assuming that a person whose license is revoked would be driving if they continuously drive, even if they continuously stop individuals and notice that no other person has a revoked license when they're stopped? But also the last question that I had about certain groups getting the benefit of the doubt. So Justice Sotomayor stressed that this is essentially authorizing racial profiling, and how implicit and explicit bias will be used as an excuse to stop certain people more than others. I will stop there on Glover.
Any Judge Daniel? I've got one thing to say about Glover, but
yeah, one thought, if you don't mind, I really appreciated in Justice Sotomayor's dissent, her saying that the decision reduces the state's burden of proof. And I think that's a procedural hole down which we can't afford to fall. I mean, again, there has to be an appropriate showing of evidence. We aren't required to admit our wrongdoing or even to disprove unless there's good reason. So that was reason for concern. I think to expect officers to investigate it sufficiently and not just base decisions on empirical evidence is not too much.
Judge, so Justice Sotomayor also said, like, or asked, like, how do you disprove it? How, like, it's not only shifting the burden, but it's also, even when you get the burden, how do you prove that the officer wasn't reasonable? So yeah, I appreciate you bringing that up.
yeah, Carla, your summary was great. I mean, it actually reduces the incentive of officers to investigate. It's better to stop the car right off the bat than to look and see whether, for example, the appearance of the driver matches what you know about the registered owner. If the registered owner is 65 and male and the driver is a teenage female, you should not stop the car, but this reduces the incentive to investigate. So thank you for that. I wanted to just point out, Justice Kagan really tried hard. This is an example of Kagan trying to use whatever little authority she has to try to move things around. And I think actually it explains maybe her agreeing to join the dissent in Ramos, like I'll join the dissent in this one where it doesn't change the result. And maybe I'll get something in the future. Here she said, basically, this could only work in Kansas because of Kansas's weird, very extreme revocation of license authority, but it might not work in other states. The majority did not dispute that. And so lower courts that are outside of Kansas can still perhaps not allow this one fact, reasonable suspicion analysis to work. We'll see. And the other point about this is Justice Breyer, oddly enough, has been a conservative on the Fourth Amendment ever since he came onto the court. So they didn't have 4 dissenters here. They only had, because Breyer was with the majority. And that is a surprising fact. And one imagines that if Justice Breyer were to leave the court, somebody who were appointed might be more liberal if it were a Democrat were in the president. See, so there's another appointment, even by a Democratic president, where justice could make a difference. So, are we going to go back now to Daniel?
Yeah, sure. So I'll discuss Kaler really quickly. It's a case for the Kansas. And the case was billed as whether it was constitutional for Kansas to abolish the insanity defense under the Due Process Clause, but it was a little bit more nuanced than that. So historically, there are 2 variants of the insanity defense. The first discusses cognitive incapacity, meaning that a defendant was unable to understand his actions due to some kind of mental illness. And the other kind is moral incapacity, meaning that the defendant understood his actions, but because of mental illness, did not understand their wrongfulness or their blameworthiness. And so Kansas abolished the second form of the insanity defense. So, and the opinion gives an example. So if a defendant shoots somebody, but introduces evidence that they didn't realize what a gun was or how a gun works, and therefore didn't understand kind of their actions, then in Kansas, they can be found not guilty by reason of insanity. However, if a defendant shoots someone because God told them to, due to a mental illness, that defendant could not be found not guilty by reason of insanity in Kansas. And so the question is, does due process require a defendant to be able to raise a moral incapacity insanity defense? And to answer that question, the court really does a deep dive into history to determine if that variant of insanity is deeply rooted in our Anglo-American legal history. And Justice Kagan, writing for a 6-justice majority, looks at a bunch of legal texts and treatises from early England and early American jurisprudence, and comes to the determination that no, the moral incapacity version of the insanity defense is not so deeply rooted such that it's required by due process. And her reason is essentially that because our understanding of insanity and mental illness has evolved so much over the past 300 years, and because the insanity defense really varies in its formulation by state and has varied over time in the same state, you can't say that this one species of insanity is so deeply rooted that is required by due process. Justice Breyer dissented, joined by Justice Ginsburg and Justice Sotomayor. And Justice Breyer looks at the same kind of history and the same texts, and he comes to the opposite conclusion. And he said, no, moral incapacity has always been part of our understanding of the insanity defense. And Justice Breyer really takes a step back and says, like, let's look at the bigger picture. As a society, we have made the decision to say that we do not hold people criminally responsible for conduct that they don't understand to be wrong. Whether that's because they don't understand the nature of their actions or because they don't understand the wrongfulness of their actions. And there's really, in his view, no difference in the culpability between those two classes of defendants. And Justice Breyer also makes a really important common sense point in that he says when a defendant most often raises the insanity defense, it's not a cognitive incapacity argument, it's a moral incapacity argument, it's delusions, it's some kind of compulsion to do the act driven by mental illness. So he says, in his view, that abolishing this form of the insanity defense really does do away with most of the insanity defense in Kansas. One thing I think is interesting about this case is why Kansas would feel the need to abolish the insanity defense at all. It's not as if a person who is found not guilty by reason of insanity just walks out of the courthouse that day. Oftentimes, especially if it was a crime such as a murder, that person would be committed to a mental hospital, which often looks a lot like a prison if it's not in a prison, and will spend a very long time, if not the rest of their lives there. So it's not like a person will not be incapacitated and separated from society if they're found not guilty by reason of insanity. So it seems to me at least be performative on Kansas's part and kind of play in like a fear mongering for why it would want to abolish the insanity defense, especially when under Kansas's scheme, a defendant's allowed to introduce evidence of moral incapacity at sentencing. And so a judge can commit that person at sentencing. So it really seems a little, I wonder the motivations behind Kansas abolishing this variant of the insanity defense. What else is, so it'll be interesting to see kind of what states do now, given this decision. Clearly the Supreme Court has given states some leeway to fashion or to limit insanity defenses. So it'll be interesting to see if there's any kind of fallout or kind of domino effect based on the Supreme Court's ruling in this case.
Daniel, maybe I'll use what you just said as a segue to answer a question that's in our Q&A as well, but which has to do with how lawyers lawyer in the trial court. You know, in California, they abolished a version of the insanity defense when Dan White was acquitted or at least convicted of lesser offenses based on his Twinkie defense, which was a mischaracterization really of what was going on. But the population bought it and they passed a statute saying there's no more diminished capacity defense in California. I don't know whether a similar episode happened in Kansas, but Justice Kagan seems to have a really strong faith that trial lawyers will still be able to get into the case almost every mental illness doctrine or expert testimony that they want to by saying it interferes with the creation of mens rea, and we'll see whether she's right or not. It takes frankly, I think, a very sophisticated lawyer to put on an insanity defense, and we'll see how that'll work. But lawyering will have a lot to do with it. Justice Kagan says something like, well, there's only 5 states that do this. Well, I think you're probably right that after this, there will be more states that abolish what's called an insanity defense. But lawyering matters, right? And those law students who are listening, I mean, and those lawyers who are listening, right? Aggressive trial court lawyering really can make a difference. And now you just have to attack mens rea with everything you've got. The question in the Q&A has to do with Glover. How does the fact that it was decided on stipulated facts alter what parties might do in the future suppression hearings? So I'll say something that probably my panelists would not say, but I have the protection of being old and having tenure. The defense lawyer in this case did a lousy job. A defense lawyer should just never let the government get away with stipulated facts. Why do they do that? Because judges pressure them to when the docket is full. What else are you going to dispute? They make them sort of say their motion before they can make their motion. But a lawyer, and Justice Kagan in oral argument of that case really stressed this, the lawyer could have asked lots of questions of this agent. Well, what's your real training and experience with regard to people with revoked licenses? What did you actually notice about the car, about the driver, about what did you actually read when you read the registration revocation bulletin you got on your radio? How did that actually work in your mind? Where was your reasonable suspicion? You might not win as a matter of law. You might win as a matter of fact with a judge who suddenly realizes the officer is kind of talking out of his or her hat. So you're going to have to lawyer more aggressively now, because really, I'll say this too, Justice Thomas has a view of reasonable suspicion, which is anything a police officer says is reasonable suspicion. I mean, he just has no standard whatsoever. I'm sorry to be so blunt. Daniel, go ahead.
Yeah, so I actually had the complete opposite reaction. I think this goes back to something the judge said is, I would think that the government would need to do more to prove that the stop was constitutional. So to me, it doesn't seem unreasonable to say like, well, these are the only facts you're stipulated to. No judge in the right mind will say this is enough for reasonable suspicion. And if you look at Justice Thomas's opinion, he has to supplement this officer's reasoning with all these statistics and kind of these, a lot of conjecture about what a reasonable officer would know based on stuff that is completely not in the record. So I mean, obviously I don't know the defense attorney in this case, but I wonder if that defense attorney was just like, wow, the government is really phoning it in on this one. If they stipulate based on one fact, there's no way that that's going to be enough to kind of get over the, to prove their burden of showing this stop was constitutional. But yeah, for judges like Justice Thomas, a defense attorney would have to kind of be more vigilant in kind of exposing the gaps in the officer's knowledge. But I think Carla made this point, which I appreciate, is that it kind of flips the burden when it's the government's job to do it. And now it's like the defendant has to walk back the officer's knowledge in some way based on this one fact. So I could understand why it worked out the way that it did. But yeah, it's just not a great court for these types of claims.
I mean, Carla was certainly right when she started by saying, how would you answer these questions in your own mind? How would you answer these questions in your common sense? And I think a lot of people would. I got to tell you, my kids drive my car all the time, and they're not the registered owner.
Are you making an admission?
Well, yeah. Next time I get stopped, I'm gonna hire Daniel or Carla to be my lawyer.
I say something that we've talked about Collar and Glover sort of together, and to piggyback on your mention to the young lawyers out there that lawyering matters. It does, but we've talked about two different things, and I just want to unpack for a moment. Issue spotting. that pesky old requirement in law school really matters, because when you're talking about a Glover situation, it's really your intellectual resources, right? The ability to ask questions, get answers, follow up, not really costing much more than time and energy. But in a collar kind of situation, we're talking about resources that might cost, maybe evaluations and experts. And many states are low on those kinds of resources. So these litigants are going to have to be vigilant and to ask the court for what's necessary, but maybe unaffordable. So lawyering matters indeed, and voting in every election matters, Professor Little.
Absolutely. Okay. Daniel, I think you had one more case you were going to talk about, and then we can go back to Carla.
Yeah, I see we're running low on time, so maybe I just say a quick word. So one case I'm keeping an eye out for next term is Jones v. Mississippi, which concerns the finding necessary to sentence a juvenile in prison to life in prison without the possibility of parole. So the Supreme Court has said in a case, Miller v. Alabama, then in Montgomery v. Louisiana, that only the rarest of the rare juvenile offenders should be sentenced to life without parole. And in fact, it's unconstitutional to sentence a juvenile to life without parole unless they are, in the court's words, irretrievably depraved, irreparably corrupt, or permanently incorrigible. And aside, I take issue with whether we can ever call somebody for permanently incorrigible based on something they did as a child. But the Supreme Court at least suggests that there are a class of juvenile offenders that fit within that category. Mississippi does not require a permanent incorrigibility finding before sentencing a juvenile to life without parole. All the judge has to do is consider their youth more generally, and then the judge can hand down the sentence. So I think this case really is important to kind of, as it speaks to whether we in fact treat juveniles differently than adults, and whether we think children are redeemable, and whether you are more than the worst thing that you've ever done, especially when your brain wasn't fully formed at the time when you did it and you don't appreciate consequences and lack maturity. And by all accounts, Brett Jones, the petitioner in this case, has been a model inmate for the past decade. He has grown and matured, and the state witnesses all speak glowingly of him. And so I think this is a really interesting case that calls into question the way we punish and the way we view punishment, especially children, and what is necessary to sentence kids to the maximum punishment available since they are not eligible for the death penalty.
Right. That's a very big case. It's a replacement for the Malvo case, the DC sniper case, which was resolved when they actually changed their law. So yeah, that's a huge case. Carla, I'm going to exercise the power of the moderator and say, you take the next, whatever we've got, 15, no, not even 10 minutes, and then, or 5, and do your thing, and then we're going to go right to Q&A.
What's funny was I was going to say that I was going to take the power of panelists and do less of one case to do another case that I'm really passionate about. So
do that case.
On the same page. I will say for a Bannister, which I was supposed to talk about, on a habeas case, motion to alter and amend judgment versus a new claim. A pro se litigant filed a federal habeas petition in the district court, was denied, then filed pro se his pleadings in the Supreme Court, US Supreme Court. And my overall conclusion with that is to recognize the importance of law libraries in prisons and jails, access to legal material, and better training for law clerks in prison facilities. But we'll go to Razor, which is an order and a motion to stay. In this case, a voting rights restoration for people with felonies in the state of Florida. We've talked and joked about the importance of elections, especially in November, but then the question becomes who's allowed to vote. In Florida, for a very long time, the only way one could, who has a felony, could register to vote was to go through this clemency process, and depending on who was in the governor's mansion would determine who could get their voting rights restored. And celebrities like LeBron James and John Legend have donated their time and their money to helping people with felonies, also called returning citizens, in Florida now. But before the celebrities came in, there was a people-led movement fueled by directly incarcerated, directly impacted people. The Florida Rights Restoration Coalition, which was created by Desmond Meade, a formerly incarcerated individual, pushed for a citizens ballot initiative with additional support from larger institutions like ACLU of Florida and League of Women Voters of Florida. That push led to, in 2018, November 2018, 65% of Florida voters supporting Amendment 4. It was the fourth amendment on the ballot. It was also the most popular amendment on the ballot, even though it was fourth, to allow the automatic restoration of voting rights for people with felonies, except for those convicted of murder offenses and sexual offenses. A bill was passed in July 2019 that made voting dependent on paying their legal financial obligations, so fines, fees, and restitution. Several federal lawsuits then were filed. A preliminary injunction prohibiting the 2018 or 2019 state law was issued in 2019. It was upheld by the 11th Circuit three-judge panel in February 2020. Fast forward to May of 2020, when the district court judge entered a permanent injunction and really made the process much more, streamlined the process so that people with felonies who could not afford to pay outstanding legal financial obligations could register to vote. In July of 2020, however, the 11th Circuit stated that opinion without opinion, and that stay was appealed by the plaintiffs, and the Supreme Court decided to decline to lift the stay. The focus of the Razor decision this past term was on Justice Sotomayor's decision on that, and really just railing on the disenfranchisement or the continued disenfranchisement of individuals. At least 1 million people could be affected by this ruling, people who cannot afford potentially thousands or really hundreds of dollars in fines and fees. And Justice Sotomayor expressly noted a trend towards condoning disenfranchisement. And so some of those things that we've discussed today could be influenced by individuals voting, but we have to get access to vote first.
Well, and let's be clear, the impact of that disenfranchisement has a racial disparity, which is remarkably strong, and people are well aware of it. And by not allowing the district courts, this will get me to a general theme, Judge Pearson, you may agree with it, which is we ought to give just district courts a fair amount of authority when they hold evidentiary hearings and make certain conclusions, right? And then it goes up to the Supreme Court and they don't have any of that. If a district court judge imposes a stay and it's affirmed by a panel, we should take it seriously.
Absolutely, I agree. We do quite a bit of heavy lifting and after deep, thoughtful process. In fact, one of the processes going on in many of the courts around the nation is how we can continue that with the pandemic. I mean, we're not putting up opaque walls, we're putting up transparent walls, because it's important that when a witness is testifying, we can look over at the witness and attempt to judge credibility to inform a record. So I believe I have on many occasions had the opportunity to wish that trial court judges, this one included, were given more discretion. But the system works, and this is another opportunity for us to reach out to the litigants who might be doing the lawyering, the young lawyers or even the more experienced ones. When I sentence someone, I usually, at some point during the hearing or maybe even during the plea, like to speak about rights that are being given up. if you're being incarcerated, you're not going to be able to vote. But when you're released, your first job should be to seek to restore your right to vote. And while you're still on paper, you may not be able to vote, but you may be eligible for some federal funds, second chance funds, to pay down certain fees, not penalties, but if the fees are paid down, maybe you can pay your own penalties, and by George, next election, maybe you're ready to vote. So it's a discussion worth having.
Okay, great, thank you. We've got about 11 minutes. I'm going to do something very quickly here, which is I'm going to share one screen. Here's the McGirt case. I got asked the question in the Q&A, can you say something about McGirt? I don't know what to say about it other than I think it's the sleeper case of the term because no one's heard of it. The bottom line is 43% of Oklahoma is now still, quote, Indian territory because of an 1832 and 33 treaty, which was never revoked by Congress. Justice Gorsuch wrote this 5-4 opinion, and it really affects the question of who's got criminal jurisdiction in various cases. And we're talking hundreds of cases, not just a few. And now instead of the state having criminal jurisdiction, it'll have to be federal. There may be a small category of cases of minor offenses where no one has jurisdiction. And Oklahoma is struggling with all of the broad consequences of this decision. So while it is a criminal jurisdiction case, it's actually a huge case. And it's a big victory, if you want to call it a victory, for the Native American rights. And Justice Gorsuch, here's the Western maverick. He says these treaties meant something. And we're not gonna pretend that they didn't mean something just because everybody has ignored them and sort of stepped all over them for many years. That's my one share on that. I was also asked to say something about Kelly. All I can say about Kelly, this is Bridgegate. All I can say about Kelly is the federal mail fraud statute, wire fraud statute, they're the same effectively, has been limited pretty dramatically in ways that it had been broadly interpreted previously ever since 1988 in a case called McNally. And this limits it even further. It turns out that if a politician or a policymaker lies about why they've instituted certain regulatory power that they have, that is not going to be viewed as mail fraud or wire fraud, even though it's fraudulent. There may be other state remedies, but as far as federal remedies go, it narrows a little further the extent of the mail fraud statute to be able to regulate or control or address political corruption at a state level. And that's all I'm going to say about that, because Judge Pearson, I don't know if you wanted to respond to this, but I see a question from Daniel Deckard, who's a former student of mine 10 some years ago, I think, about, well, how are they going to enforce or how are they going to apply the tests in Mazars for congressional subpoenas? And let me just say, Justice Roberts notices, in his opinion, this is the first time we've ever been asked to talk about congressional subpoenas. So it's pretty tough to say how are they going to do it on remand. But Judge, what are your thoughts about Mazars?
Well, at least in the room where I work, it works pretty effectively. Then when it's written about in the decision, even if it's not enumerated at the end of the decision on remand, the court has its marching orders. And I think it's articulated pretty well what at least 4 factors are that the majority expects the trial court to take up in deciding, the implication of separation of powers. And believe me, there's nothing about Mazars that makes me think that there could be no further appellate review. Simply means there must be remand taking up these factors. And if there's further dissatisfaction, I'm sure the appellate courts will be there to take up the dispute.
Yeah, it's the 2 opinions, Vance and Mazars, were interesting in the sense that everyone seemed to consider Vance to be a big victory for the district attorney in New York. And somehow they thought Mazars was a defeat, if you will, for the congressional committee. Now, the oral argument, I have to say, the lawyer representing the House of Representatives took a very strong position and basically said every subpoena has to be enforced. And the court rejected that. But I also think it's important, Judge, what you just said. District court judges read these opinions carefully. And when the court says, here's factors you must consider, they consider them. It's not just meaningless verbiage. Right or wrong,
discretion, but not unfettered discretion. I think we should be reasonably expected to follow the rulings of superior courts. And I don't think anyone would disagree that the Supreme Court is superior to all federal trial courts.
Right. We're also asked in this Q&A, are there any more sleeper treaties out there? Well, that's one of the big questions. There are certainly a number of Native American organizations and tribes who believe that there are sleeper treaties. Treaties in the sense that they made promises that haven't been kept. And Justice Gorsuch actually says this in his opinion. He says, boy, the federal government has done a lot of things that are in contravention of these treaties from 1832, 1833. And they may mean one thing or another, but they don't change the fact that those treaties were in force. And just the fact that the federal government has kind of stepped all over other parts of these treaties over time doesn't reduce their enforceability. So I think there is more litigation to come. I know in California, there's a lot of concern about what else may be out there. And this case addressed the Creek Nation. There are lots of other Native American nations out there that were part of the Trail of Tears in the 1830s. So it's unclear. We also got a question, and I don't, maybe one of the other panelists knows as much or more about this than I do. It's from Linda Greenhouse. So what this means is none of us know as much as Linda Greenhouse. She's the former Pulitzer Prize winning reporter on the Supreme Court from the New York Times, who teaches at Yale Law School. She says, have we got any thoughts about, and I don't know how to say the name, thuricigium, which has to do with expedited removal. And a conservative majority basically allows an expedited removal process in that case. And she says they seem to confine Boumediene to its facts. And all I can say about that is I think that's right. I also think they did that. I can't remember the name of the case. There's another immigration case where they also seem to confine Boumediene to its facts. Boumediene is the famous case in the wake of September 11th that said that non-citizens still have a right to habeas corpus even when they're in Guatemala or Guantanamo Bay, I'm sorry. Powerful endorsement of the Due Process Clause and liberty interest written, my memory is by Justice Stevens, and also Justice O'Connor played a role. So for the court now to be stepping back from that just, I think, shows that the moment of threat that we felt in the mid-2000s from the Guantanamo Bay detention camps seems to have faded in the face of other threats we're facing. But does anyone else have any knowledge of this case, which I can't even pronounce? Daniel, anything on this one?
No, I got nothing.
As usual, Linda Greenhouse is ahead of us. Okay, go ahead, Daniel.
Yeah, so I did want to say one quick thing about McGirt, which I think is interesting and maybe says something about what will happen next term, is Justice Gorsuch really dismisses the idea of what Justice Brennan once upon a time called too much justice. So Oklahoma really did a lot of flailing and complaining that if you do this, you're going to upset the cart. We don't know what's going to happen. The world's going to end. The sky's going to fall. And Justice Gorsuch said, be that as it may, we are here to enforce the law. So I think that could portend well in the Edwards case, where they decided Ramos is applies retroactively, because a lot of Louisiana's law argument was about how it will upset 1,600 convictions, and who knows what they'll do in that situation. So that could be a good sign. But I also thought it was a really important acknowledgement that kind of practical consequences can't trump constitutional legal principles. And I also thought his kind of statements about how the government has often broken its promises to people was really interesting when you think, again, if you brought it out to this bigger moment about reparations and the treatment of Native people in the country. And so I just think, McGirt, there's just so much there, and it's a muscular view of textualism and how you don't consider anything else. It's a really fascinating case in a lot of ways that I think will have really interesting implications.
That's great.
Can I?
Yes, please.
just to add on to what might be a theory that Professor Harawa just identified, similarly in Justice Sotomayor's concurring opinion in Ramos, she said, and I think it's found its way into your notes that the audience will get, Professor Little, the force of stare decisis is that it's nadir concerning criminal procedure rules that implicate fundamental constitutional protections. And then she goes on to say, you know, bravely, like Justice Harawa just mentioned regarding McGirt, where the state's power to imprison those like Ramos, remember, life without parole, on a less than unanimous jury, rests on erroneous interpretation of jury right, the court should not hesitate to reconsider its precedents. So it seems that at least certain members of the court are willing to turn things upside down or at least do them differently when justice so requires, and that's the job.
Can I just add one thing? Like that question and that statement, the conversation that y'all are having is what we often do in classrooms. And so as like law students are hearing and wondering why are we having this discussion, the justices of the Supreme Court are also having this discussion, and it's important to realize that.
I have to tell you all, when I read McGirt, I tweeted out on my Twitter account, this means maybe they're ready to overrule McCleskey versus Kemp, which is where Justice Brennan famously said in dissent, the majority seems to be afraid of too much justice. Because the majority said, oh, we can't find race disparity to be a factor here because, oh my gosh, what would that mean for the whole system? And Brennan said, well, you know, don't be afraid. I'm going to share my screen one more time here, assuming I can get it up. So here's a list of 1, 2, 3, 4, 5, 6 cases where certs granted for next semester, which are some big cases we didn't mention. But while it's up there, any closing remarks from our panelists? Judge Pearson, Daniel, Carla?
Well, thank you for having me. It's my first time working with a group of you, and it's been delightful. And I certainly hope we've imparted some information that's helpful to our audience, and look forward to doing it again.
Great. This is my closing slide. I want to thank everybody who stayed so long. I'm not able to see how many participants, but at one point we were up to 176, which is probably more than we've ever had for this panel in person. And I'm sure that's because of the attraction of our speakers, Professor Laroche, Professor Harawa, I'm so sorry, and Professor Judge Pearson. Thank you so much for participating. Thanks to the Criminal Justice Section for sponsoring it. I do expect you'll get materials within, let's say, a couple of weeks. Classes are about to start remotely for us professors, so it's a little busy. And I hope to see you all next year at this same time. Thank you very much.
Thank you, Rory, for moderating this. This was wonderful. Thank you.
Thanks, everyone.